Article 34, Constitution of India 1950. Right to private property. Article 34 was not part of the draft Constitution 1948. It was introduced and debated in the Assembly towards the end of the constitution-making process on 14 and 16 November 1949. The article restricted fundamental rights during the operation of martial law by giving officers of the state certain powers. Two substantive amendments were moved to oppose the article. The first wanted to delete the draft article as it was an open invitation to officers of the state to indulge in excesses during martial law. The second wanted to remove any person from the text, arguing that there was no need to extend the immunity provided the article to individuals who were not officers of the state. Both amendments were countered. First, it was explained that a military officer, to successfully engage with a situation of insurrection or rebellion or the overthrow of the state, required the ability to pass orders and prescribe procedures for cases where their orders were violated. These powers were barred by Article 20 and 21, as the military officer was not a law-making person and the procedure that they prescribe would not come under procedures according to law. The draft article, therefore, was indispensable for the military or any officer of the state to discharge their duties effectively during martial law. Further, it was clarified that in some cases, the onus might shift on a civilian who might not be an officer of the state to act in ways to deal with a martial law situation. In these cases, the civilian's actions must come under the ambit of the draft article. Ultimately, the Assembly adopted Article 34 with no amendment. Right to private property. The right to property ceased to be a fundamental right by the Constitution, 44th Amendment, Act, 1978, however, it continued to be a human right in a welfare state, and a constitutional right under Article 300A of the Constitution. Article 300A provides that no person shall be deprived of his property save by authority of law. The state cannot dispossess a citizen of his property except in accordance with the procedure established by law. The obligation to pay compensation, though not expressly included in Article 300A, can be inferred in that article. In other words, to forcibly dispossess a person of his private property, without following due process of law, would be violative of a human right, as also the constitutional right under Article 300A of the Constitution. Judgment of the Supreme Court. On January 8, a verdict was given by a bench of Justices Ajay Rastogi and Indu Malhotra that the right to property is a human right. The Supreme Court observed in its judgment that the state cannot take possession of a person's private property without following due procedure of the laws. This verdict was given in a case where the government of Himachal Pradesh had forcibly taken 4 acres of private land to build a road. This incident had occurred in 1967, at a village in Hamirpur district, in Himachal Pradesh. Justice Malhotra highlighted the failure of the Himachal Pradesh government to pay compensation for 52 years, to the appellant, who was a widow and illiterate. Justice Malhotra empathized that the appellant had not filed any proceedings for the failure of the state government to pay land compensation, as the appellant was from a rural background and who was not educated enough to know her entitlements and rights given to her by the law. After many years, the appellant moved to the Supreme Court. Initially, she had filed a case in the High Court, but the High Court had asked to file a civil suit in the lower court, hence the Supreme Court was approached. The Supreme Court observed in its judgment that the state becomes an encroacher when it grabs the private property of a person without following due process of law. The Supreme Court ordered the government to pay a compensation of 1 crore rupees to the 80-year-old appellant. Right to property, fundamental right and 44th Amendment in 1978. The Supreme Court observed that when the incident took place in 1967, the right to property was still a fundamental right under Article 31. Article 31, 2, had mentioned that only after due compensation was paid to the person by the government would get the right to take over private property and use it only for public purposes. Article 31, 1, of the Constitution had made it clear that private property could not be taken by the government through an executive order but only through the authority of law. The above laws were preventing the government from carrying out public infrastructure projects and other agrarian reforms as people started approaching the courts during the land acquisition by the government. Hence there was an amendment to the Constitution of India in 1978. It was the 44th Amendment of the Constitution of India which declared that the right to property will no longer be a fundamental right. Article 31 and Article 19(1) F was completely removed from Part 3, Fundamental Rights of Constitution, with the help of the 44th Amendment. Thank you.